Mr. Speaker, I move that urgency be accorded the introduction and first reading of the Video Camera Surveillance Temporary Measures Bill and the Sleepover Wages Settlement Bill, and for Sue Kedgley to give her valedictory statement at 5:45 as determined by the Business Committee. Mr. Speaker, as members will be aware, the recent Supreme Court decision in Hammett and others with regard to the use of video surveillance has serious implications for both current prosecutions in cases already before the courts and ongoing investigations by the police and other law enforcement agencies. Government has decided it's vital we ensure that the police cameras that are currently switched off are switched back on as soon as possible. Therefore, we intend to introduce the bill and pass it after a brief select committee consideration to preserve the common law as it has been understood by successive governments, police, Court of Appeal before the Supreme Court decision of 2 December. The bill is an interim measure and will, if Parliament passes it, remain in force for no longer than 12 months to enable a permanent regime to be put in place. With regard to the Sleepover Wages Settlement Bill, this is also the product of a court decision. Following the finding by the Court of Appeal that sleepovers constituted work for the purposes of the Minimum Wage Act 1983 and that the minimum wage apply for each and every hour worked, a settlement was reached between Idea Services Limited, Tamata Ho Limited and the Services and Food Workers Union. Cabinet has agreed to the settlement to which the Crown contributes, and this would provide the framework for settlement of these issues. The passage of the Sleepover Wages Settlement Bill is required to implement this settlement. Both of these bills will be considered by select committees until next Monday.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. Party vote's called for. I'll ask the clerk for a party vote.
New Zealand National.
57 votes in favour.
New Zealand Labour.
42 votes in favour.
Green Party.
9 votes opposed.
Act New Zealand.
5 votes in favour.
Māori Party.
Toko whae tau toko an.
Progressive.
1 vote in favour.
United Future.
1 vote in favour.
Mana.
1 vote opposed.
Honourable Chris Carter.
1 vote opposed.
Members, the ayes are 110, the noes are 11. The motion is agreed to. A point of order, Gareth Hughes.
I just wish to clarify for the House that Sue Kedgley's valedictory approval was given at the House at 2 p.m. today. In voting and opposing the House's use of urgency, we weren't explicitly voting to oppose Sue Kedgley's
No, I understand that. That has been clarified by the Leader of the House, so that is fine.
Video Camera Surveillance Temporary Measures Bill, introduction.
The bill is set down for first reading forthwith.
Mr. Speaker.
The Honourable Christopher Finlayson.
Mr. Speaker, I move that the Video Camera Surveillance Temporary Measures Bill be now read a first time at the appropriate time. I intend to move that the Video Camera Surveillance Temporary Measures Bill be considered by the Justice and Electoral Committee, that the committee report to the House on or before 3 October 2011, and that the committee have authority to meet tomorrow and at any time while the House is sitting, except during oral questions, during any evening on a day on which there has been a sitting of the House, and on a Friday in a week in which there has been a sitting of the House, despite Standing Orders 187 and 191B and C. Mr. Speaker, for the last 17 years, the police have used covert video surveillance cameras. They've used them to help investigate serious crimes, including drug dealing and organised criminal gangs. They've been used both to gather evidence and to obtain information. On at least 6 occasions, the Court of Appeal has considered the admissibility of evidence obtained by these means. These cases involve video cameras deployed both outside and within the property to be searched and concealed on an informant transacting drug dealing business inside the suspect's home. On 2 very recent occasions, the Court of Appeal ruled the use of covert filming to be a legitimate component of a power to search pursuant to a warrant. Contrary to some public comment, the police were accordingly justified in their belief that the use of the surveillance in connection with a search warrant was not unlawful. Lawfulness is to be distinguished from unreasonableness. That filming allowed by the Court of Appeal was always subject to a challenge under Section 21 of the New Zealand Bill of Rights Act based on unreasonableness. That situation will not change under this bill. Last month, the Supreme Court retrospectively altered the law. It ruled that in the absence of specific statutory authorisation, the use of covert video surveillance amounting to a search and conducted in tandem with a Summary Proceedings Act search warrant was unlawful. While not strictly part of the decision of the court, its reasoning would also apply to searches using that technique from surveillance points outside the target property. The decision of the court affects approximately 40 criminal cases now before the courts and at least the same number of current police criminal investigations. The bulk of these cases involve serious drug and organised criminal offending. Also affected is the ability of many statutory organisations to carry out their responsibilities. Mr. Speaker, it's important to note that this bill does not seek to overturn any decision. It temporarily holds the law of New Zealand applying to covert video surveillance to be that laid down by the courts before the Supreme Court in Hamed reversed that legal position. The bill accordingly preserves the legal position as it was before 2 September 2011. Because, as it must, the judgment affects all relevant cases and conduct before 2 September, the bill suspends temporarily that effect of the judgment as well as provides for the period before the bill is enacted. Clause 3 sets out its purpose. That is to provide a temporary period to enable Parliament to move with all deliberate speed to pass the Search and Surveillance Bill. That bill, among other things, comprehensively covers the accepted long-term goals of bringing covert video surveillance under the control of carefully scrutinised statutory provisions. As would be expected, that clause also provides that nothing in the bill affects the rights of those persons who have obtained the benefit of the Supreme Court's judgment in Hamed. Clause 4 sets out the necessary definitions. It's important to note that the bill does not give the police or any other agency the ability to enter onto private property for the purpose only of seeking visual evidence from covert video surveillance. The entry onto private property where covert video surveillance is intended must be pursuant to a warrant issued under Section 198 of the Summary Proceedings Act, and that warrant must be issued and executed according to existing law. As I've already noted, surveillance will remain subject to a challenge under Section 21 of the New Zealand Bill of Rights Act based on unreasonableness. The situation differs from the bill as released for consultation by me last week. Clause 5 declares that post, current or future searches may not be held to be unlawful only because covert video surveillance was used in connection with a search. As originally drafted, Clause 5.2 would have provided that the use of covert video surveillance does not of itself render the search unlawful or unreasonable. That would have affected the way in which courts might otherwise in the future apply the right to be free from unreasonable search. I've listened to the criticism of this limitation on the Section 21 Bill of Rights right and have not included that provision in the bill as introduced. Clause 5.3 is intended to augment Clause 5.2. The latter clause deals with the lawfulness of any use of covert video surveillance. Clause 5.3 is essentially an avoidance of doubt provision directed to the essential question of the admissibility of evidence. By way of explanation, if evidence is found to be improperly obtained within the meaning of Section 30 of the Evidence Act 2006, it's liable to be excluded unless the result would be disproportionate to the seriousness of the crime. The intention in the bill is that if the only basis for objecting to the admissibility of the evidence is that covert video surveillance was used, the evidence may not be treated as improperly obtained. Critically, however, because of the matters I've mentioned as to Clause 5.2, if for any reason the search is found otherwise unreasonable or indeed otherwise unlawful, the evidence may or may not be excluded on the basis of the existing law. Mr. Speaker, in conclusion, can I say this? We find ourselves in a difficult legal situation. It's a situation contrary to the public interest and the safety of the public and law enforcement officers. It will be some months before a new Parliament can pass the Search and Surveillance Bill into law. Contrary to some claims I've heard, it would be impossibly complex to enact parts of that law early. I've taken the advice of PCO on this point, and I agree with them entirely. And I understand my colleague, the Minister of Justice, is going to say some more about this later in the debate, and I look forward to what Mr. Parker will say. Unless this Parliament takes action now, the police and other statutory agencies will be denied for some time the ability to use a technology that has become an indispensable facility in relation to the safety of police officers and the detection of serious criminal offending. This is not a situation that can stand. I commend the bill to the House.
The question is that the motion be agreed to. Charles Cheval.
Speaker, thank you for the opportunity.